Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Thank you so much for joining us today. My name is Alaina Davalos, and I will be joined by Dominic Parillo, our Director of Wealth Transfer. We will be talking about Estate Planning 101, hopefully giving y'all some good information about the basics of estate planning, some terminologies, things like that. Thank you, Dom, for joining us.
Well, thank you so much for the introduction to the program, Alaina. So excited to be here. We've got a great program. We're going to cover a slide with an overview of the topics that we're going to run through. But you'll notice that we're going to be using some terminology. We're going to send everyone that's registered for the webinar a glossary of all the key terms, so you can reference that if you go back and rewatch the presentation or refer to the slides. And also a copy of Savant's Estate and Trust Administrator's Guide, which is a great resource for your executors and trustees in the future to help get organized. And we'll give everyone a sneak peek of that towards the end of today's presentation. So thank you again for joining us, everyone. All right. And we go to the next slide, Alaina. You can pull up our agenda. Okay, so we're going to start basic. Like Alaina said, this is Estate Planning 101. And you might find yourself someone who has an existing estate plan, but maybe it's been a number of years, right? And it's time to dust off those documents and refresh your memory on how your plan works. Or maybe you haven't started the process for putting your formal estate plan in place. So we want to redefine what estate planning is, why it's important, cover the key documents that you'll want to put together with your attorney, what they are, how they work. And then I think very importantly, and you're going to cover this, Alaina, an overview of how property passes its death, because your documents themselves can control how your assets pass, but the titling, beneficiary designations might actually trump the terms of your written estate plan, and that's something that's often missed. Another key aspect of estate planning is communicating your plan with your loved ones. We want to give you some tips and tricks there. And then Alaina is going to give us an overview of the probate process. That's a term that I think most of our listeners may have heard before or may have acted as an executor in the past, if you've been in one of those roles. And then no estate planning presentation is complete with at least a little bit of a discussion on taxes and how those might affect your loved ones. So we're going to cover that. And then, of course, at the end, some Q&A.
Great. Well, thanks, Dom. Let's get started. What is estate planning?
All right. So I always like to break the ice a little bit. Do you know, and this is somewhat of a rhetorical question, what Abraham Lincoln and Jimi Hendrix had in common?
I don't know. What is it?
Both of them died without an estate plan. And one of the important things we want to emphasize is that everybody can benefit from a formal estate plan. Everyone's busy with their families, their careers, right? Just things that might have more importance to them than thinking about sitting down with their attorney, right, their financial advisor, and putting their plan in place. So very important. Estate planning is really the process of designating who's going to receive your assets, your stuff when you pass away, and naming responsible parties who are going to handle the administration of your estate. Some common goals for estate planning are minimizing costs and expenses, creating clear and concise operations, making sure that asset protection provisions are in place if that's important, and really promoting family harmony. And if you don't have an estate plan yet, at least a written estate plan, remember that everyone actually has a default estate plan, and your default estate plan is governed by the laws of the state that you live in. So if you die without a written estate plan, a will, and we'll talk about that document in particular in a moment, you're considered to have died intestate without a will. And the state of your residence that you pass away in actually dictates how your estate passes, right? The beneficiaries who receive your money, your other assets. And those beneficiaries that are defined under state intestacy laws might not be the individuals that you actually want to leave your money to. And it's very important, especially if you have a blended family, a child with special needs, right? A special circumstance, if you're wanting to disinherit a family member, to really formalize your estate plan and have a voice and a say in how your assets actually pass. On the next slide, a couple of key points, right? Again, I'm going to reinforce this. If you don't have an estate plan, when do you need to start thinking about putting one in place? Right now, as we're speaking, right? It's so important. Everybody needs an estate plan. Everybody can benefit from a written plan. And then once you put that plan in place, it's very good to review the terms of that plan, your balance sheet, net worth information, beneficiary designations regularly. We have up on the slide an annual sort of time frame. I think at least annually you want to look at your beneficiary designations and your net worth statement just to see if there's any changes in title. Keep an eye on asset values. But I would say, I think you would agree with me here, Alaina. Anytime there's a major change in your life, a death of a loved one, birth of a child, birth of a grandchild, major change in estate tax thresholds or income tax rules, it's probably good to go ahead and readdress the key terms of your plan with your financial advisor and attorney who helped you put the plan together. Okay.
I agree, Dom. I used to tell my clients when I was in private practice that what my responsibility as their attorney was in terms of their ongoing estate plan was to notify them if the law changed or if something significant happened that they wouldn't necessarily know about. Whereas their responsibility would be to notify me if they did have this major life event, if someone passed away or they were worried about incapacity. And so it's definitely part of team building to make sure that you're in communication with your advisors.
Great point. And we find that many clients and families we work with, might have infrequent communication with their attorney, right? And might not remember a lot of the key details. So good to stay on top of this stuff and review things from time to time. Okay, well, let's dive into the key estate planning documents that everybody should have. And we're going to cover these in sort of the order of operations of when the document would actually be needed. And hopefully everybody has at least seen these terms before. Power of attorney for property and healthcare documents, living wills, advance directives, last wills and testaments, and in many cases, revocable living trusts make sense. So let's start with power of attorney documents. Okay. And when would a power of attorney document really be used? It's typically used when someone is unable to make financial decisions or healthcare decisions for themselves, because that power of attorney document allows you, the principal, the person that's creating the document, to appoint an agent who can act on your behalf as if they were you and do a lot of things that you could do. And not only are power of attorney documents important in the event that you're incapacitated, but we find that as people get older, their children or other loved ones who may be nominated as agents under their power of attorney documents might take a more proactive role in assisting with their financial transactions. So having that power of attorney in place for that event makes a lot of sense as well. Because if an asset is in your name individually, only you can provide instructions on that bank account, write checks, Without a power of attorney document in place, if you become incapacitated legally and you're unable to make decisions for yourself, a court would have to appoint a guardian or conservator, which might not be the person that you have in mind to step in and make those decisions for you. And that's a very sometimes embarrassing process. It's expensive, right? Generally, we want to avoid that. So another important reason to get these documents in place and work towards that if you don't have your estate plan. So the power of attorney for property document covers your financial assets in life. Your agent can pay expenses on your behalf, file income tax returns on your behalf, right? Make IRA, individual retirement account distributions. So any financial transaction generally covered under the power of attorney for property. And most states have a separate document that'll cover healthcare decisions. Sometimes it's referred to as a power of attorney for healthcare document or a healthcare surrogate nomination document. It depends on where in the country you live in, but they all generally do the same thing. Your named agent can make healthcare decisions on your behalf. And then to take it a step further, very important that you create a living will declaration, which is different than a last will and testament that distributes your estate at death, or at least governs how that should work. A living will declaration or advance directive allows you to specify to your agent, the person who's going to be making healthcare decisions, and your physician, how you want your end of life treatment to go. So, whether or not you want artificial nutrition or hydration, right? Very important decisions. So you can remove the burden of making those very difficult end of life decisions from the shoulders of your agents and other loved ones. Okay, so hopefully that gives everybody a sense of what these power of attorney documents are and what they do. Very key to your estate plan.
Dom, can I ask you, are there generally any limitations on who you can name as your agents in these roles?
The big limitation that comes to my mind is generally the person that you nominate has to be over the age of 18 or whatever the age of majority is in the state that you live in. So it's not always the same. I think it's 19 in Alabama, one of the unique states. Sometimes that person can't have a felony record. I know that's a requirement for executor appointments, right? But in general, just from more of a practical standpoint, you're going to want to choose someone who you trust, right? And I think that the best agents that you can nominate are going to be people that are not procrastinators, right? People that are going to be responsive if something needs to be done, right? Not hesitant to pick up the phone and call your financial advisor, your attorney to get direction. Because the people that you nominate in your document, they don't necessarily have to be an expert in financial matters, right? They don't have to be a medical professional. No, they're just the person that's going to be making decisions, acting in your best interest in a fiduciary capacity. So I think that's the most important thing, right? And if you're a married person, right, maybe your spouse would be your primary agent. If you have adult children, maybe those adult children, or if you don't have children or don't have adult children, maybe your children are still very young, parents or siblings. And I think it's good too, just as a tip, to have multiple agents named in the document as a backstop in the event that first named person is unavailable to act, right? Maybe they predecease you. Maybe, they're incapacitated themselves. Maybe they decline to accept the agent appointment, right? You don't always have to serve in that role, even if you're nominated in the document. So great question, Alaina. Some very practical stuff there. And then I mentioned earlier that there's two other documents that are some of the basic building blocks of an estate plan. So I want, Alaina, you to cover those if you can. That'd be the last will and the revocable living trust documents.
Yeah, of course. Thank you, Dom, for that information. about your powers of attorney. So as you mentioned, the other big part of any estate plan is going to be a last will and testament. And many people are familiar with that term. The will is usually the core part of your estate plan because it details what happens to your assets at your death. So what is a will? A will is a legal document that expresses a person's wishes as to how their property is to be distributed after their death and names a person to manage the property until the final distribution, called the executor. A person who creates a will is called a testator. You may also sometimes hear the feminine version, which is the testatrix. That is a fun word to say. And unlike your powers of attorney that can come into effect while you're still living, your will only comes into effect once you've passed away. So let me reiterate that. Your will only comes into effect once you've passed away. What this means is that a will can be changed up until your death, so long as you have your testamentary capacity. And what does testamentary capacity mean? It means that you have the mental and legal ability, as determined by your state's laws, to create a valid will. If you do not have testamentary capacity, you cannot change or create a will. So this definition becomes very important when someone starts dealing with physical and mental health issues that affect their ability to understand what they're signing, such as Alzheimer's and dementia. So generally, how do you create a will? Again, state law controls what makes a will valid. So the requirements to make a will in Georgia, where I'm based, may be different than the requirements to make a will in Virginia, where Dom is based. There may be certain requirements as to how many witnesses you need, whether you need a notary, whether the will can be digitally signed, which is a new thing that we're seeing now. Some states do allow a handwritten will, which is called a holographic will, to be valid without witnesses, while other states do not recognize holographic wills. It's very important to understand what makes a will valid in your state, which is why it's usually best to consult with a local attorney to see what your options are. The other big question that comes with wills and estate planning is what assets pass under your will? And this is a really big planning point. So please note that your will only controls certain assets. And those are going to be assets that are in your name at the time of your death that you generally do not have a joint owner. If you have property joint tenants with rights of survivorship, those assets will not pass under your will, as well as assets that don't have a beneficiary designation or a POD or TOD, which stands for payable or transfer on death designation. A bank account or a brokerage account in your name alone, yes, those will generally pass under your will. A 401k or an IRA that has your spouse listed as the primary beneficiary, no, that will not pass to your spouse under your will. It would instead pass via that designated beneficiary. A piece of real estate you own with your siblings as joint tenants with rights of survivorship, no, that real estate will pass to your siblings automatically. I'm going to show you a graph in a minute that goes into a bit more detail about how different assets pass. So one of the downsides of passing assets under your will is that usually the will must go through the probate process. Probate is the act of proving a will. And again, I'm going to give you a little bit more details about this in a minute. For the general construction of the will, you'll need to determine who are the beneficiaries. Generally, you can benefit anyone you like under your will. In some states, it can be harder to disinherit a spouse or minor children. So again, make sure you talk to your legal counsel about that if you're considering it. But for most people, your will can leave your assets to anyone that you would like. Also, in many wills, you'll see that there is a separate distribution of personal property, which is your stuff, things like your jewelry, your cars, your silverware, versus the bulk of your estate, the residue, everything else that your will controls. When I was in private practice, a lot of clients, again, struggled with what to do with their stuff because nowadays, a lot of people, a lot of children, they don't want their parents' fine china or their big furniture. The kids are already set and established in life with their own objects. So that was a really big struggle for a lot of clients is what do I do with all of this stuff that no one wants? A lot of states will allow for your personal property to be distributed via a separate memorandum. So instead of writing everything down in your will, you can have a separate piece of paper. There's a little bit less formality that goes into creating that list. So if you don't want your china to go to your sister and some jewelry to go to your grandkids, but everything else goes to your spouse, you can specify those gifts outside of the will itself. That just makes it a lot easier to distribute that personal property without having to formally redo your will every time you change your mind about who's getting your coin collection or your keychains. For the residue, the bulk, everything else outside of your stuff, you can make specific gifts, percentage gifts, or formula gifts. You could say, for example, I leave 10% of my estate to my church and the balance to my kids. You could also say something like, I leave $50,000 to each of my nieces and nephews and the balance to my siblings. You could do any combination of the two. The world, or the will in this case, is your oyster when it comes to deciding who receives your assets. You can also generally decide to leave assets outright to the beneficiary or in trust. The most basic wills will say, I leave everything outright to my spouse, and if my spouse doesn't survive me, I leave everything outright to my kids. More complicated wills will create testamentary, irrevocable trusts for spouses or other descendants. These trusts can provide substantial asset protection and or tax planning opportunities for the beneficiaries of your will that you generally couldn't have with an outright distribution. So I think that trusts have a bad reputation of the testator, the person that created the will, controlling assets from the grave. However, recent changes to many states' laws have made trusts much more attractive and lenient, with the chosen trustee having a lot of flexibility over making distributions. So if you do decide to incorporate these trusts into your will, they're called testamentary trusts because they're created under your last will and testament. And these are not to be confused with another common estate planning tool that we use, which is called a revocable living trust. So a revocable living trust, or RLT for short, is a trust that can be changed by the grantor, which is the person who creates the trust, during their lifetime. One common misconception I see a lot is people confusing the living trust with a living will. As Dom mentioned, a living will is a healthcare document that states how a person wants to be treated medically if they are unable to make their own decisions due to a terminal illness or permanent unconsciousness. The living trust, which I'm talking about here, is a tool used to avoid probate and to plan for incapacity. So these are very different tools. With an RLT, the grantor names an initial trustee and beneficiary who are usually the grantor themselves. Sometimes a spouse is included as a co-trustee or a permissible beneficiary of the trust. What's in the RLT? It usually covers 3 scenarios. The first scenario is while the grantor is alive. The second scenario is when the grantor passes away but is survived by a spouse. And the third scenario is at the surviving spouse's death, or if the spouse did not survive the grantor, when it comes time for the kids to inherit. Those second and third scenarios, where a spouse or descendants inherit from the grantor, those can be the exact same provisions as in a will. An RLT is most commonly used as a will substitute in order to avoid probate. Because unlike a human, a trust doesn't die. It can terminate, but it won't just pass away when its grantor does. So the assets that it holds do not need to go through the probate process. You can have the same asset protection, create the same testamentary trust, do anything you could do under a will with an RLT, but have it be a lot easier process for your beneficiaries. So why doesn't everyone have an RLT? First, because they can be more expensive to establish. A revocable trust itself is usually a longer document, and it generally has the pour-over will that goes with it as well. And that's just in case the grantor of the trust does have probate assets in their name at their death. You want everything to pass cohesively via the terms of the trust. So the pour-over will passes those assets from the probate estate to the revocable trust. And then that successor trustee distributes everything cohesively. The other big problem that dissuades a lot of people from using a revocable trust is that it does need to be funded during the lifetime of the grantor to be effective. That means that assets need to be moved into the name of the trust. So if you've got real estate, that real estate needs to be deeded to the trust. If you've got a brokerage account, you need to change the ownership of the account to the trust or add the trust as a payable on death beneficiary. This can be a lot of homework for some people that aren't up to the challenge. I will say, the really good thing about working with a financial advisor or RIA such as Savant is that we can help you to move your assets into the trust and really take advantage of the structure that the RLT provides. One other thing to note about taxes is that during the grantor's lifetime, the revocable trust uses the grantor's social security number, so creating and funding the RLT has no impact on the grantor's income or estate taxes. At the grantor's death, an irrevocable administrative trust may be established that needs to file for a new EIN with the IRS, which is an entity identification number. If spousal subtrusts or subtrusts for descendants are created, they will also need a new EIN to file their own tax returns. If you ever encounter an irrevocable trust that was set up under a will or an RLT, please make sure you consult with a qualified CPA because there is a lot of tax ramifications that go along with irrevocable testamentary trusts. So whether you've got a will or a revocable trust, it will name your people, who are generally called your fiduciaries. The primary person in a will is going to be an executor. An executor is a person or institution appointed by the testator to carry out the terms of the will. So the person who's going to be responsible for transferring assets from the testator's name to the final beneficiary, who is also named in the will. If you have minor children, your will may create a trust for their benefit. And in that case, the will also name a trustee, who is the person that holds and administers property for the benefit of the beneficiary under the terms of the trust. So again, if you have minor children, the one other important position that a lot of people worry about is also the legal guardian. Who is going to have legal responsibility over my minor children if I decease while they're still minors? Your will name that legal guardian, and they would have physical custody of them. In a revocable trust, the trust agreement doesn't name an executor. Instead, it names a successor trustee to the grantor. So the initial trustee would be the grantor, then their spouse, for example, then their oldest child. A lot of times I would have clients that would name all of their children, usually in age order, so that none of them felt unappreciated. Um, this appointment of a successor trustee is also how these trusts help with incapacity, because the successor trustee is there to manage the trust assets on behalf of the grantor if the grantor loses their mental capacity. Family members wouldn't have to go through that process that Dom was talking about earlier. They wouldn't have to go to the court to be appointed as guardian or conservator because they would already have legal assets to what has been moved into the trust and could make decisions about those assets on the grantor's behalf. And just to reiterate, what Dom said before too, in choosing your people for these positions, you can pick 1, 2, or 3 people. Legally, you can do as many as you like, but logistically, it does get harder the more people that you have named. If you do name more than one person in this role, let's say a successor trustee, you'll also need to decide if those people need to act jointly or if they can each act on their own independently. Also, you can name the same person in each role. The same person you name as your financial power of attorney can be your executor and successor trustee. That's usually a pretty natural flow since those 3 roles all have to do with managing your money. But there's no requirement to do so. A lot of times I've seen clients really struggle with choosing their people. Um, if there's an obvious choice, such as your parents, your siblings, or close friends, and it can actually lead to a lot of people not doing their estate planning, or putting it off for years. There was a client once that just said, I'm not going to sign my will and hope I make it to 18 because I can't pick a guardian for my children. I definitely don't recommend that. Something is better than nothing. Because if something does happen to you and your spouse, the last thing that you want to have happen is for a family member, whoever has interest in your children, to have to go to the court to decide who has legal guardianship over your children and to institute a conservatorship to manage their inheritance. This can be very stressful and a very expensive procedure for your family. So please, especially if you have minor children, get a will done that takes care of them. If you can't think of a person, if there's no one that you trust or think would be in a good role for your fiduciaries, your executor, trustee, there are corporate fiduciaries who are available to act in these roles. Here at Savant, we have Savant Private Trust, which operates via National Advisors Trust Company. That allows us as the financial managers to work hand in hand with our clients that have established these trusts for one reason or another. So you do always have options. So with all these,
Before you cover this next section, one thing that often comes up, and I think you hear this a lot, is I understand the benefits of having a will and a trust, but I know that I have the ability to add beneficiaries to accounts. And this is going to go directly to this next slide that you're going to talk about. The big disadvantage of relying on probate avoidance techniques like payable on death instructions, transfer on death instructions. I know you covered those terms earlier. is a lack of asset protection when those assets are actually paid to the named individual on the beneficiary form. So could you give us a sense of um, how um, a family creating their estate plan can make sure that they're achieving the asset protection goals that they might have as well? Because I know you mentioned that, and I know you have a lot of expertise here. I think that's something that's often missed, right? When people think they have the will in place, it's covering everything. What are some of the pitfalls that you've seen in practice when a young person, a young child inherits a large sum of money? I think that'd be really important if you agree to cover, and I know you're going to layer that in here as well on this next slide.
So let me just say, like I mentioned, one of the biggest advantages and things that you can do with your will is to create those testamentary trusts. I would say, Dom, this is a little bit more estate planning 102. So everyone should sign up for our next webinar. But what is, with those testamentary trusts, when you leave assets outright to someone, they are free to do with it what they will. It's a demonstrable problem with minors because in most states, minors cannot hold assets until they reach a certain age. But you also have other issues when you have a beneficiary with addiction issues, or that your loved one is not going to be able to handle this money that they have inherited. And so if you see that coming, one of the best things you can do is institute those testamentary trusts. Instead of saying, I leave everything to my daughter, you say, I leave everything to my sister as trustee for the benefit of my daughter. Let's say she's a minor. Great. She can have access to her trust when she reaches age 25. You write those terms down in your will. Let's say, though, my daughter has addiction issues. She's never going to be able to manage this money by herself. You say, okay, I'm going to leave this money in trust for my daughter for the rest of her life. My trustee will be able to make distributions to her for her health, education, maintenance, and support. That's a distribution standard used by the IRS, so a lot of attorneys like to use it. And that says, trustee, okay, you can make distributions to her to help her pay for her apartment, for her to go back to school, for her to get a car, something like that. But you're not saying, hey, I've got a $100,000 life insurance policy. I'm going to give it over directly to my daughter with drug and alcohol issues because we know what she's going to go and spend it on. So if you have any concerns like that for your family members, and that's extended beyond minority, creating those testamentary trusts, it's not necessarily controlling from the grave. It's taking what you know about your family and making sure that your legacy, everything that you worked hard for during your life, is not going to be wasted. And this does actually lead into my next discussion about how property passes. Because, let's say you do set up these testamentary trusts. You've got all these ideas you put into your will. But if I go and name my daughter outright as my beneficiary in my 401k, those funds are going to go to her. It's going to skip over the terms of my trust, which is why it's very important when you have these different assets to make sure everything aligns as part of your overall plan. And so, we talked about the will and the revocable living trust, but those documents only control a portion of your assets. For example, your assets that you gift away during your lifetime. This is a commonly forgotten about part of estate planning, I think. If you gift these assets away, they don't need to go through probate. Shocker, that's because they're not a part of your estate anymore. You no longer have control over them. Crazy how that works, right? So your lifetime gifting, though, can impact your estate tax exemption about, which Dom is going to talk about in a little bit. And that controls how much your estate owes in estate taxes at your death. Just generally, you can make gifts above $19,000. You can make a gift up to $19,000 a year to any one person without having to use any of your lifetime exemption or file any gift tax return. If you do make these large gifts, you should consult with your attorney and your CPA just to make sure your state tax exposure is that it's a good idea to be making these large gifts. And one thing to note is that $19,000 number is controlled by Congress and is adjusted for inflation. So it may change every year. Generally, if you gift over that amount, if you're single, or double that amount if you're married, you will need to file a 709 gift tax return. And depending on what you're gifting, if it's straight cash, that's relatively easy. If you're gifting business interest or you're gifting real estate, that can either be very easy or very complicated. So make sure you consult your advisors. I will say one of the biggest lifetime gifts that I see that clients want to do is they want to gift interest in their real estate, their home, to their children in order to avoid probate. And there are some negative tax consequences to that. So I generally don't recommend that. There's a lot of other tools, including that revocable living trust, that can be used to avoid probate in a more tax efficient way. So if you're thinking about gifting real estate to your kids, please consult your advisors first. The other main way that assets pass at death is via beneficiary designation. So I've mentioned this a few times, many qualified accounts, including 401ks and IRAs, they pass via beneficiary designation where you've notified the custodian of those accounts that at your death, those accounts will pass automatically to that beneficiary. Anytime that you're updating your estate plan, you need to make sure you update your beneficiary designations accordingly. Dom mentioned this earlier. That should be part of your annual review. If you're meeting with your advisor, if you're doing it yourself, check your beneficiary designations, make sure they make sense. The same thing goes though with property that is held jointly. Property that is held as joint tenants with rights of survivorship passes automatically to the surviving owner. Property that's held as tenants in common generally does not. If you're trying to avoid probate by having all assets pass via that joint ownership, a tenancy in common can ruin your overall plan and cause your will to have to go through probate unexpectedly. The other big tool that you can use is the TOD or POD, transfer on death, payable on death, and you can add that sort of transfer to your regular checking and savings, your money market, things like that. Works the same as a beneficiary designation, where that asset will automatically pass to your beneficiary. Other assets such as 529s, those usually have what's called a successor owner. So again, make sure that aligns with your plan. And then once all that's done, because doing your estate planning is a work in progress. It's not something you sign the documents, you set them aside, but it's making sure that everything passes cohesively and the way that it should. So aligning all of these assets can be very important. I hope you guys like this chart here because this is what Dom and I spend most of our days doing when we're not presenting, and it's making charts like this for our clients so that they can see exactly how their plan is going to work at their death and see if there's anything that needs to be done before that event occurs. We look at jointly held assets, estate planning documents, assets passing via beneficiary, assets that are outside of their taxable estate, all those things. We want to make sure that our client's estate, which they've usually worked their whole lives for, is going to pass as seamlessly as it can to their final beneficiaries according to their final wishes. Excuse me. On this chart here, you'll see that we have an example of a joint revocable trust that creates tax efficient spousal trusts for the survivor of them, and then creates lifetime descendants trust for their kids and other descendants. This is a bit more of a complicated plan, but it's what's best. So now what? You've got your documents in place. What do? Dom, can you give us some pointers?
Absolutely. And thank you, Alaina. You've masterfully covered the advantages of having testamentary trusts and revocable trusts. And I think we emphasize the importance of not taking any shortcuts, right? If you have real concerns about any of your beneficiaries. So hopefully what Alaina said really resonated with everyone. And again, now is the time to start thinking about your estate plan or reviewing what you already have, just to make sure everything is going to work as expected. So once you have the basic building blocks in place and you've reviewed the titling of your assets, the beneficiary designations, aligned everything, you may consider communicating key aspects of your plan to your loved ones or the fiduciaries that you've named. And Alaina had that wonderful slide that defined each different fiduciary that could act under the documents. So thanks again, Alaina, for that. And you know, it's when you communicate your plan, it's not that you have to share every intimate detail of your financial life, or even necessarily the details of the documents themselves with your loved ones. And when you think about estate planning, you're really balancing a lot of different factors, right? Efficiency of administration post-death, making sure there's decision makers in place, who those decision makers are. We gave you some good tips and tricks on maybe thinking through that, the people you name, minimizing tax. I think the most important thing on this slide is the last bullet point: preserving harmony, avoiding disputes, ambiguities in the future. So at a bare minimum, we always suggest that clients, when they put their estate plan in place, is to let their beneficiaries, whether you have children or you don't have children, that there is a plan in place. Here's the contact information for my attorney and my financial advisor if something were to happen to me, and get a fireproof safe for your home to hold these important documents and other important financial statements, right? So you can create a trail of breadcrumbs. On the next slide, we'll showcase the Estate and Trust Administrator's Guide that our team at Savant has put together to help you start gathering some of this important information, like who to contact if something happens to you. Again, where are important documents located? The phone number, address, email address for your financial advisor, your attorney, your insurance agent, right? There's a lot of individuals, financial professionals, and otherwise that play a key role in your overall financial life. Have you prearranged or thought about your funeral or burial or memorial arrangements, right? Sometimes spelling those details out can relieve a lot of uncertainty, stress, and decision-making from your loved one's shoulders in the future. Alaina mentioned earlier that when you create your last will and testament, oftentimes there are provisions that allow you to distribute your personal, tangible property, right? The things in your home, your furniture, coin collections, the things that don't have legal title, like a bank account or a vehicle, you can dispose of with a personal property memorandum. And that's something, quite honestly, when I'm reviewing estate plans, and I think you're probably seeing this too, that isn't done all that often. Now, that could be because as Alaina said, beneficiaries have too much stuff of their own and they don't want your things. So there might be a trend for people to donate items to their, during their lifetime to Goodwill, Army, organizations like that. Maybe they're, gifting the heirlooms to their children, grandchildren, their loved ones during their life. And, the plan is to sort of declutter. But it's something really important, I think, to not overlook because people do fight over, the more sentimental items. And your legal documents themselves, your will, your trust, they spell out the fiduciaries that you've named, how assets are to be held and distributed. Is it outright? Is it in trust, as Alaina described? But the documents don't often capture the context or your intent behind the plan. So sometimes it's important to create a separate letter of instruction or an ethical will statement that says, hey, here was my vision. This is why I created the plan. Here's how I intend, the trustee to make decisions. Here's helpful information about my family, that sort of thing. We spoke earlier about choosing fiduciaries. There's a lot of options. The big one, of course, that Alaina covered in detail was the trustee, right? Is it going to be a family member? Is it going to be a independent, trustee like a trust company, that sort of thing? But the amount of information that you share and whom you share it with is really going to be dependent on your age in life, the age of your children or intended beneficiaries. I think it's important to share the who to contact, where things are located. Maybe as your children or your agents start to take a little bit more of a proactive role in your life, you can start sharing some of the other details, values, that sort of thing. Because if you have a young family or your intended beneficiaries are younger, you might not want them to know what that future expectancy inheritance is going to look like, because that might, impact their work ethic and their outlook on life. I know we have about 8 minutes left in our discussion, so let's move to the next slide. And this is a sort of a replay of the slide that Alaina had up on earlier. And what we wanted to do here was really just highlight again that estate planning can be complicated depending on the design of your estate plan. And it's not a one and done exercise that ends when you sign your documents. It's important, as Alaina said, to make sure that your beneficiary designations are aligned, that your trusts are funded if probate avoidance is the goal. So just reinforcing those concepts here. Get in touch with your financial advisor, start reviewing your balance sheet. You could have A+ documents, right, that are perfect, but then when you pass away, you get a C-, right, because you have loose assets that are now subject to probate, right? Young beneficiaries or beneficiaries who didn't intend to have outright access to funds getting an IRA account because it bypassed the terms of your estate plan, for example. So take that away with you after we hang up. Just a good thing to keep in mind. Alaina, I don't know if we're going to have a lot of time to talk about the probate process. I think
I'm going to zip through it. I'm going to give y'all as general of a summary of the probate process I can. And I mean, even if we had more time, even if we had all day, I can't go into a lot of details anyways, because probate is very state specific and I don't want to get sued. But I can give you a 30,000-foot view. So generally, most people's knowledge about executors and the probate process comes from TV. On TV, there's usually a gathering of the family in the lawyer's office. Everyone's waiting with bated breath to see what they're going to inherit. The executors announce. It's all very dramatic, not what the family expected. In reality, a lot of times, because as Dom mentioned, people have these open and honest communications with their family. Usually this is not a spectacular event. The person who passed away is called the decedent. They either had a last will and testament or they didn't. If they had a will, it named an executor. And just so y'all know, the will may also refer to that person as a personal representative or an administrator. Just for this topic today, I'm going to use the term executor. So generally what happens with the probate, the family has to find the will. It's usually with the personal effects in a safety deposit box, or it's with a drafting attorney. Most wills are written in modern English and are relatively easy to understand. Sometimes there can be a lot of language in the document. I myself was known to draft a 50-page will on occasion, but identifying the nominated executor is usually pretty easy. And one thing again to reiterate, the executor is not automatically in power. Just because they are named in the will does not mean that they immediately have the authority to act on behalf of the decedent's estate. That's because they still need to go through the probate process. They need to be appointed by the court and given that legal authority. One other thing to reiterate again, is that the executor does not have control over all of the assets. They don't have control over assets that had a joint owner or a beneficiary designation, a POD or a TOD. They only have control over those assets in the decedent's name at the time of their death. If you have a revocable living trust, you'll have a trustee instead of an executor. The roles can be very similar. You are responsible for administrating the trust, collecting the trust assets, whether those come from the probate estate or that named the trust as the beneficiary. The trustee then pays any taxes, debts, or administration fees not paid by the executor. Sometimes the revocable trust will morph into an irrevocable trust. In this slide you see here, we've got that revocable living trust that changes into a trust for the survivor, which in this case is the surviving spouse. At that surviving spouse's death, the trust changes again into subtrusts for children. Those children's subtrusts are generally irrevocable. And as I mentioned before, these trusts can be created for a variety of reasons, usually of which is asset protection. The trustee will then take on the responsibility of managing this trust long-term, filing any trust tax returns that are required, and making distributions to the beneficiary. So as opposed to being an executor, which is a short-term role, the trustee can be a long-term duty. So do make sure you're aware of that if you're nominated as a trustee. It's also important to differentiate between these roles because they're controlled by different documents. The trustee is subject to the terms of the trust agreement, and the executor is subject to the rules of the court and the terms of the will. Dom, can you just very quickly, very briefly tell us a little bit about everyone's favorite topic, which is taxes?
I'd be happy to. And I know we're coming up on time. I think we're going to go a little bit over because we do want to have a couple of questions answered. Again, this webinar is going to be recorded. So if you need to jump and attend other things you have planned, that's totally fine. But one of the big questions that we get from people when they lose a parent or their loved one is, do I have to pay tax on this inheritance? Right. And one of the major taxes that could be implicated is an estate tax, which is the tax on the transfer of wealth at your death. And there's two systems. There's a federal estate tax system and possibly a state estate tax, depending on what state you live in. On the next slide, we have a map of those states that have either a state-based estate tax or an inheritance tax. But if we jump back to that first slide, you'll notice that there's been an upward trend, and we're sort of operating under this historically high federal estate tax system that was heavily impacted by the passage of the Tax Cuts and Jobs Act, which doubled the basic exclusion, the amount that you can pass estate tax free to your loved ones, from $5 million to $10 million, adjusted for inflation. So here in 2025, we actually have a $13.99 million federal estate tax exemption. If you're a married couple, that's almost $28 million that you could pass estate tax free to your loved ones. But that number is subject to change. Right now, the debate in Congress is whether to extend those Tax Cuts and Jobs Act exemptions, which are set to expire at the end of this year. This is something we're going to keep an eye on. Again, depending on your level of wealth, you may or may not be subject to estate tax. Income tax is a different tax system, and the income tax is going to be dependent on the type of asset that you inherit. So, Alaina, you talked a lot about qualified plans, IRAs, and 401ks. When monies are withdrawn from those types of assets as the inheritor, ordinary income tax is paid. If you inherit a capital gain type asset, right, not an IRA or qualified plan, capital gains taxes apply, which are often less in many cases than ordinary income rates. It depends on what income tax bracket you're in. But capital gains rates are either 0, 15, or 20% generally. So again, estate tax is based on the value of your wealth that you pass. A lot of families aren't subject to estate tax. Income tax is based on the type of asset that you actually receive. On the last slide, and I swear it's the last slide, we had just an overview of some of the important tax filings that need to be done when someone passes away. Again, this is going to be handled by your executor or your trustee in the future. That's something that's often overlooked. The big thing that I'll emphasize here is that if you're married and your spouse passes away, very important to consider filing an estate tax return, Federal Form 706 or 706, because there's a lot of uncertainty what that estate tax exemption might look like. And you can do a portability filing to make sure you're not losing the benefit of your deceased spouse's federal exemption and pass more wealth to your loved ones estate tax free. And with that, we've covered some of the basics on tax, and I think we have time for maybe 1 or 2 questions. Again, we'll send this recording out.
And you're right, Dom. We won't have time to address everyone's questions live today. So if you would like to discuss your unique situation, please schedule a complimentary 15-minute call by clicking the link in the chat to schedule a time that works for you. And I am going to go ahead and look to see what a couple of our questions are. So, Dom, do I need a will if I have a trust? You want to take this one?
I'd be happy to. That's an excellent question. And Alaina, you covered the key differences between a will and a trust, but generally everybody needs a will. I think everybody can benefit from a trust, especially if your goal is probate avoidance. The reason the will is key is because it's the document that will allow you to nominate guardians for minor children. That's the only document in which you can do that. So you don't want to not have that in place. And it allows you to nominate your personal representative or executor, which again, if you have a trust, if there's a loose asset, probate's needed, you got to have that executor nominated. And that executor is the first person that files your estate tax returns and estate income tax returns, claims refunds. So you have to have both. But at a bare minimum, the will is what you need.
Cool. One other question here. I'm named as the executor in my parents' will. Do I have to do it? So, no, you are generally not legally obligated to act as the executor. Most times you can decline to act in that role. Most wills will have a successor named. So, if not you, then your sibling or a close friend, that successor could step into your place. If you can act for some reason and someone needs to be appointed, there is always someone for the court to appoint, whether that's a professional, whether that's someone that works for the county. Here in Georgia, we have our county administrators that step into that role. There's usually always someone. The biggest issue that you run into is that those third parties or those non-related parties will usually take their executor's fees more often than a family nominated member will. And speaking of fees is our last question. Dom, I'm going to give this one over to you. What is the cost of setting up an estate plan?
Well, Alaina, you're going to love this. It depends,
I
right?
do love that. That's a great answer. Yeah.
Um, no, it's a good question because when you create your formal estate plan, it's really an investment that you're making for your loved ones in the future, right? And the cost is going to vary greatly by the area of the country that you live in,
Mhm.
right? So costs vary by region. And then the complexity of the documents that you're using, right? What your needs are. If you need advanced estate and gift tax planning with generation skipping, transfer provisions, that's probably going to cost more than a basic will plan where you're just paying assets outright to your spouse and children. So I don't let the cost stop you from going down the path to getting your ideal estate plan put in place. Ask that question up front, right before you commit to that attorney that you're going to be working with. A lot of attorneys work on project fee bases where there's a fixed cost, maybe with hourly charges if there's some extraordinary time applied. Great question. Thank you all so much again for attending today's webinar. We hope to see you again soon, and hopefully this information was valuable. Take care.
Thanks. Bye, y'all.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.